for. So first and foremost, thank you very much for attending my class. Okay, a few disclaimer. I'm just a very junior lawyers, and I do not guarantee this class will actually benefit you. And the outline of the answer is of my own personal opinion. This is not a academic reference, and this is obviously not the answer by LPQB. So just use with your utmost caution. So I'll first read the question. Okay, this is your compulsory question. It started with Korab commence a civil suit for defamation. Okay, evidence paper very important for you to distinguish number one, whether this is a civil suit or criminal suit. First thing, when you read the question, your mind map should go in two way, whether this a civil suit or criminal suit. So this is a civil suit. What is the cause of action? The cause of action is a defamation case against Suu Kyi. So Suu Kyi made some derogatory statement in the Twitter's account, now identified as X. See, this is X. It does not contain the name of Suu Kyi. Okay. The statement labeled corrupt as corrupt. Okay, just like the name suggests, dishonest, hypocrite, snake, by right, it's snake, huh? It's snake and lalang. The ownership of the Twitter account by Suu Kyi was not in dispute. Okay, just pay attention to every single word inside the examination question, because examiners wouldn't simply put a fact for no reason. It is for you to use this fact to support your case. However, Suu Kyi contested the ownership of this derogatory tweet, asserting that they were posted during a period when Suu Kyi was away on an excursion to Mount Everest. So he went to climb the mountain. So he said that the account belonged to me, but I was not the one that posted the derogatory statement. I did not do the defamatory act. So Korab's claim was dismissed by Session Court, which held that he had not sufficiently demonstrated Suu Kyi's authorship of the tweets. The Session Court's decision rested on the ground that Korab failed to discharge the burden of proof on balance of probabilities that Suu Kyi was responsible for publishing the derogatory tweets. Korab has enlisted your service to represent him in appealing against the Session Court judge decision. So you are acting for the plaintiff, okay? So this is Korab to go for appeal. So that means to say during the appeal, you must state what mistake that the Session Court judge had made. Okay, that means to say what is the grounds of your appeal. Okay, render this Session Court judge decision is not a good decision. So you are asked to explain how you will argue the points on appeal by reference to the Evidence Act and relevant case law on the burden and standard of proof on the parties concerned. So quite a good marks, 15 marks. Okay, whenever you see a 15 marks question, you must be mentally prepared that you are going to give a quite lengthy answer. It's not a short and just some point form, then finish off the story. If you do like that, probably you'll get a fail marks for your examination. Okay. So you generally the outline of the answer should contain a good and brief introduction, what you want to say later, and what is the thing here. Okay. So I will put my draft as such. In the case at hand, Mr. Korab seeks to appeal the Session Court dismissal on his defamation suit against Mr. Suu Kyi. So the primary issue is whether Mr. Su, the admitted, because just now from the fact you can see that the ownership of the Twitter account is actually not being disputed at all. So that means to say the account belongs to Su Qi. So what left with the next? Whether he published or he's the one that uh, write the derogatory statement like corrupt, dishonest, all that. Is it important or not? Is it the point that should be considered by the judge or not? Okay, so I will highlight to High Court. Okay, take for example High Court. I will use section 4, the general section for presumption, section 106 as well as section 114 and other case law to support my ideas or my submission that the session court judge had erred in reaching his or her decision. Okay, this is how you start. I know many of you can answer, and you can actually identify on the spot this is a pure section 114A question. But having said so, you must consider the marks behind it. Uh, we have a lot of marks, 15 marks. They don't just want you to talk about section 114A itself. No, they want you to have thinking like a practical lawyer based on the very short facts that you have derived from the question. Okay, first, in order for you to succeed in this appeal, you must still prove that the plaintiff, corrupt, had actually fulfilled all the ingredients under the thought of defamation. Okay, so defamation itself is a form of cautious action, and no doubt we have a Defamation Act 1957, but it doesn't say much about the ingredient of the defamation. Okay, so online publication in this particular regards, Twitter accounts post is a permanent form of it's not a transient thing, it's not just like verbal thing. So this will be constituting a form of libel, and you can find the definition of a libel under section 3 of Defamation Act. This is how you start. And second thing, you must establish what are the elements of defamation in brief. So the story already told you defamatory statements. What are them? For example, corrupt, dishonest, hypocrite, snake, etc. are actually prima facie already. You see or not? Those words are not the good words. And it is referring to corrupt, isn't it? This one is also not dispute. And the third element is publication. It's like you spread this thing to third party. So as long as this is a Twitter public, social media platform, so it will be deemed that you have spread the news or spread the rumors to the parties. So all three elements of the so-called the Defamation Tortious Act had been fulfilled, uh, had been done by this the defendant, and Mr. Corrupt here would just need to establish the all these three things. And since the question invites you to talk about burden and also standard of proof, okay, your typical approach is that what does it mean by the word of proof? Okay, so you must get it from section 3 of Evidence Act, and then subsequently you must refer to one the what we call classic case, Jayasena. Jayasena say what? Whenever you see the word proof, cross this Evidence Act, that means this is called legal burden of proof. Whenever you see this word appear, whichever section you want to say, okay, um, to have this wording, proof, that means to say the person that want to rely on their assertion will need to produce proof, okay, to discharge such legal burden of proof. So this is to say you have to apply two general section. I said again, this is general section, section 101, okay, and in short, that means to say those who asserts must prove. Who say something, those who say something to the court and wants the court to believe what you say, you bear the legal burden of proof. This is section 101. Okay. Section 102 tells you how you discharge the thing, the legal burden. That means to say, if you take, for example, you want the court to believe that the defendant had defamed you, but then you fail to prove these three elements of tort present. You did not produce documentary evidence. You did not call any witness to say that these words already lower your reputation. Take, for example, you do not actually produce any proof. So whatever you are saying is just uh, uh something from the dog, it's like statement from the dog, which is not supported by any evidence. So you will need to discharge the legal burden pursuant to section 102 with what you have alleged. Okay, so this is the general approach. Next, you go to the discussion of standard of proof in civil case. Standard of proof in civil case are nothing much to dispute nowadays. It is on balance of probabilities, regardless what case it is. Last time we used to have some cases involving fraud, then you get a slightly higher burden, this standard of proof. But nowadays, across the civil proceeding, we are using only one standard, that is balance of probabilities. You can use whatever case you want, but the classic one is Miller against Minister of Pensions, which means more probable than not. Okay, in which to say you must say that, okay, after you have talked about the standard of proof and also burden of proof, what you do next is you have to give a brief summary saying that the session court judge had failed to appreciate the facts of this case. Already Twitter there is a defamation, refer to Mr. Koh some more, Mr. Corrupt some more. Still, the session court judge refused to give judicial consideration of the factual metrics of the case. So that means to say, whatever the conclusion or the decision that she had made is not correct. Okay, so you're not done yet. So we come to the primary discussion. Okay, we shall discuss the issue of presumption. Presumption, it works as a very um, alternative. Just now I have told you you have two general sections, section 101 and section 102. That is how you discharge legal burden, isn't it? So whatever you say in the court, you have to bear the duty to tell the court this is true and supported by evidence. But somehow or rather, don't you think this will increase the complexity and also make the whole case to be very rigid for you to prove every single allegations that you make in the court? So here come there is one law, what we call as a train of presumption. Presumptions play in this case like this. It has got two types, rebuttable presumption and irrebuttable presumption. Okay, one thing that you must know from this doctrine of presumption is that when you have shown to the court some basic some fakta asas, That means to say, take for example, if there is a drug trafficking case, okay, you have to presume you have presumption of possession and you have presumption of trafficking. All you need to do is not to show that the drugs is in the pocket during the arrest. It's not like that. You also need not to show to the judge whenever you produce the evidence during the court as DPP. You do not need to produce all that. You just need to show to the court, okay, look, judge, the weight of this drug, the net weight of this drug is more than personal consumption. So this is the basic fact that you establish. So the judge will automatically presume, since you have so many drugs, you are a drug dealer. You are trafficking the drug. This is how it works. All right. So presumption, like I said, you have two big types: rebuttable presumption and irrebuttable presumption. Rebuttable presumptions has been further classified into presumption of fact or presumption of law. Okay, what is the distinction between a presumption of fact and presumption of law here? You must pay sufficient attention to the wording. Okay, if this is what we call presumption of fact, the wording used under Section 4, Subrule 1, Evidence Act would be the court may presume. So entirely, this is discretionary. That means the court has the power whether or not to believe you once the basic fact has been proved. Okay, you get me? If it is a presumption by way of law, the court has no other option. Once you take for example the trafficking thing, once you establish there's so many kilo or tons of drugs that been confiscated, the court shall presume automatically. The court will deem the person, the arrestee, to be drug dealer, drug trafficker, like that. He has no alternative. The judge has no discretion. So this is presumption in terms of law. But you must remember the condition attached to this presumption is that this is a rebuttable presumption. What's the meaning of rebuttable presumption? Is that you have established the basic fact, but I as a defense counsel, I can also raise, okay, look, the fingerprints on all these drug packets are not belonging to my client. Look, okay, you see the tenancy agreement of this property belong to Akao instead of my client, Achong. There's no relationship. My client is just here to spend a night because he's so tired after the work. He has no way to go. Just tumpang the rumah. So whenever you have those type of rebuttal arguments, you can prove this is shakeable. This presumption can be challenged. Whereby we have a conclusive, this is a rebuttable one. If it is so conclusive, uh, then it will not be challenged, and you cannot raise any challenge as to this argument. Okay, coming back to our answer. So first you talk about general presumption, and section 114A of presumption is a type of presumption of fact. Okay, anggapan fakta. Okay, so what does it say? You talk about section 114A to make your studies interesting. Actually, section 114A had been amended, had been newly inserted in the year of 2012. That time, I'm not sure how old are you, but for me, I'm not longer old lah. We have those the Harapan is just coming up. Last time we still have Barisan Nasional, the so-called BN. So during the election, general election, Harapan that times use a lot of social media tactics. They go and defame the opponents, lah. I mean the candidates from BN. And it will be very difficult if you use anonymous account and then uh, to go and write something and you attract a lot of netizens comment. So the accountability is not there. So government put this, whoever the name, regardless you are the host, you are the moderator of a forum or Facebook group. For example, I'm the moderator of WhatsApp group. If you keep on defame on a particular person, famous one, okay, he can sue me as well. I'm liable to whatever published in the pro bono WhatsApp group. So this is how it works. So whoever the name or photograph or pseudonym appears on any publication reflecting that he is the owner, host, administrator, editor, whatsoever lah. So it's a very broad type of presumption. Okay. So it works that way. So you are deemed to be the publisher of this content. So this section had been widely applied in defamation case. Nowadays we have so many. Okay, so how do you argue and how do you apply the law is that Suchi's Twitter account now identified as X. Okay, no doubt this is X, isn't it? It's a pseudonym. It's not Suchi's real name. But however, the fact is that this ownership has never been disputed by Mr. Su. So, as an effect of this basic fact, it established the presumption that he published the defamatory statements. So this is how you uh, apply the law. Once this presumption Section 114A had been invoked, the plaintiff already cleared his legal burden. Now it is for Mr. Su to rebut the fact that he did not publish this thing. He did not publish the defamatory statement. So you can see, let me just draw for you. Initially, I told you the corrupt need to establish all the three elements. But once you invoke section 114A, there is a deemed publication. So Mr. Su Qi has to say to the court and give evidence as in why he did not publish the content. Okay? Something like that. And it is never enough in this sort of professional examination if you just take the law and then you did not quote uh, some uh, some writings. Okay, the person that you can quote is Miss Gita Radhakrishnan. He wrote a lot of articles in CLJ, all quite good. And of course, Mariette Peters. Mariette Peters, if you have any chance to attend her conference, it will be a absolutely amazing class. She is the one that look through the laws, and see beyond the things. So she actually I was lucky enough to attend some of her classes. Conference before. I seriously feel that her knowledge is extremely good. So you can quote these two names to support the idea. And in regards to defamation case, if you cannot remember anything, just remember MalaysiaKini.com, a very famous case that made this section 114A very famous. Okay, so um, And your conclusion for that is that the presumption will shift the burden to defendant, and Mr. So has to prove that he did not actually publish the defamatory content. Okay, to extend your discussion a little bit, you must say, because just now section 4, sub rule 1 already suggested to you, whenever we come to a presumption of fact, number one, it is a rebuttable one, and the court has discretion. So, as a fail-safe mechanism, the defendant, Mr. So, okay, can actually present their own evidence, say that these acts are actually not mine, it's belonging to some other anonymous line user, absolutely not mine. However, this is not being disputed, so very difficult for Mr. So to argue so. So this legal point had clearly missed by the judge. Okay, and take for example, if Mr. So had not, because this one, the fact itself is very short, but I would suggest you to include it so that it makes your answer more shine as compared to your peers. Those who have specific knowledge, take for example, in this particular case, who has this type of special or particular knowledge in regards to the ownership of Twitter account. It is Mr. So. Only he can know. Okay. And Mr. Corrupt has totally no access to, Mr. So's account, isn't it? So whenever this like this, section 106 will actually give Mr. So legal burden. So you can further argue that if, let's say, for example, the presumption, because like I said, presumption of fact, the court may not believe you. If you put this one alone in your appeal, if let's say the court did not accept your argument, okay, say section 114, yes, there's like this, but let's say the court did not buy whatever basic facts that you have established, and he refused to invoke this section 114A, then your appeal may get dismissed. So you must look a little bit broader. What else can you challenge? Okay, this is section 106. So a mere denial under section 106 is never sufficient. Okay, so I will submit as my second point here is that, okay, the session court judge did not actually correctly apply section 106 in this particular case. He or she may have as the what we call use section 101 and 102, but she used the wrong place. 102 and 102, if you use for substantive law elements, Corrupt had already discharged the legal burdens. Okay? She did not consider Section 106. And furthermore, if you read in between the line, the ownership of this Twitter account is not being disputed. Whenever in a civil case per se, if something being alleged by the opponent and you did not counter, you do not challenge, you did not dispute, you did not say no, you will deem as a form of admission. So admission under Evidence Act, just use a general one, Section 17. And whenever you have an admission, automatically no need to raise any proof. Okay, whatever facts that had been admitted, pengakuan, sejenis pengakuan, awak perlu membuktikan pengakuan tersebut. That means to say, you do not need to, or you see, already admit, you see, I have done my forensic cyber test, or this IP address belong to Mr. So. You do not need to do so because Section 58 clearly said whatever facts admitted by the parties, no need to produce any proof. Okay, so you can use a little bit of apa nama rule order 18 rule 3 of rules of court. Okay, which talk about whenever there's emissions in the pleading, if you fail to dispute or traverse seriatim, that means to say this is a form of emission lah. Okay, and at the end of the day, ah, this is my grounds of emission, what we call appeal. This is my ground. Number one, the session court judge did not pay sufficient regards to the substantive laws element, uh, which are the three ingredients of defamation. And number two, section 114 has been ignored, and burden of proof is being misapplied and overlooking at the issue of emissions. So this will be your this what we call the conclusive grounds for appeal. Okay, this is apa nama your last sentence lah. Okay, you put a firm stand. The appellate court, that is to say the high court, should set aside the session court decision and enter judgment in favor of Mr. Koh. Be a little bit more confident. So this is how you make a good living as a lawyer. If you don't become confident, I mean, you in between here and there, you very hard, I mean, to convince the client. So second question, question B, do we are we all okay? By the way, can you all follow my class so far? Or am I going too fast or too slow for you? Because we are going to discuss three questions, we have ample of time here. Are you all okay? Okay. Okay, oh good. Okay. I will answer some of your question later. Okay. Section 31 32 1B and section 73A. So basically, this question just invites you to discuss what are the differences between section 32 1B, section 73A. Okay, I put it with what we call a table, which I think is not very suitable to answer the question unless you are short time. By right, you should answer in full paragraph. Okay. Section 32, if you can go back to your Evidence Act, okay, like for those of you have joined late, I talk about the structure of Evidence Act. You must see where it is coming from, Okay, section 32 is basically coming from chapter 2, relevancy of facts. Basically, this means section 5 to section 55 are all relevancy chapter. All of them are so-called relevant facts, okay, which could be admitted by the court. Okay, section 32 is one of it. And section 73, where is it? You must see, section 73 is actually at chapter 5, which is your documentary evidence. So pay attention, because the chapter itself is not there just to put for fun, It has got meaning one. Okay. So we go back to the answer of this question. Say section 32 1B generally refer to all the statement, regardless it is a written form or it is just an oral statement. Okay, so this is a form of statement whereby section 73A is a form of document. Okay, but it is restricted for those continuous records or documents that take, for example, some account. But this section 73 A is actually a very, very good one, because most of the civil lawyer will rely on Section 73A so that they don't need to call the maker, save time and also a lot of necessary uh, hurdles. Okay, and the section the 32 1B can be applied in both civil and criminal cases, whereby Section 73A is only being used for civil proceeding. Okay, and um, to apply Section 32 1B, the maker must have personal knowledge. Okay, but the maker died. So this is it. And it has got one restriction is that Section 32 1B only apply to first-hand hearsay. So what does it mean by first-hand hearsay? Okay, take for example, I tell you, okay, this is the question. Okay, for this supplementary paper, I think judicial notice will come up. When the information passed to you, this is first-hand hearsay because I am the maker of this statement. Okay, by right, I should be invited to court to give testimony, say that I said judicial notice will be a spot question. But when it transmitted to you, this is deemed to be first-hand hearsay. But subsequently, when you tell your friends who are not present today, this becomes second-hand hearsay. Okay, so this is how Section 32 1B strictly apply only to first-hand hearsay. Okay, and second thing is Section 73A. You can prepare it because it is under the Chapter 5 of Evidence Act, isn't it? The document must be produced. It cannot just be an oral statement. You get me? So you must, this is the section that help you, that make your life easier to tender documents. Okay, the said document must be an original or a certified true copy. So this is how it works. Okay, don't confuse. So the maker, okay, Section 32 1B, as you have seen from this just now that I show you the structure of Evidence Act, isn't it? It is only being invoked when the maker is not available due to some reason. For example, death cannot come, okay, or if you try to locate, cannot find, or the cost for him to come to court is actually higher than the value of such evidence. Whereby Section 73A, the maker availability, it is not so much strict. The maker can even come. Okay, because Section 73A is sort of like the mode for you to admit this document during the civil proceeding. You want it to be labeled as exhibit, not ID. Okay, can understand? So exhibit will carry more weight. Okay, so this is how it works. And the case you can use is Allied Bank, Yao Jia Hua, okay, Arab Malaysian Merchant Bank, Chong On Po Medical Hall, etc. Okay, so uh, this is it, no? I mean, but generally speaking, Section 73A had actually made the life of a civil lawyers much better because every here and there, if let's say for example your opponent lawyer is not a very friendly type, he will put all the bundle of documents, especially those very hard to prove, under bahagian C. You have to call the maker and you have to prove the content of these documents, whether it's a forged or an authentic one. It really makes your life hard, you know. With the new enactment of Section 73A, let's say the maker is not found, this document can still be admitted as exhibit. You have no room to challenge it. This is how section 73A work. Okay, it's a very broad, wide provision for you to sort of tender uh, or get exemption of the so-called documentary hearsay requirement. Okay, can understand? Okay, so we go to second question. Second question. Wendy consulted her friend Tinko Bell, a legal manager at a bank, for advice on her plans to file for divorce against her husband. Wendy complained to Tinko Bell that Hook had recently become aggressive and agitated after he was dismissed from his job. He ranted and raved every day without fail and blamed Wendy for losing his job. He claimed that he had spent so much time providing for Wendy's expensive lifestyle that he had paid scant regard to his work, which led to his dismissal. Tinkerbell advised Wendy to leave. So Wendy called Hook in Tinkerbell's presence and informed him that she was filing for divorce. Hook got into a rage and said to her, "You can never leave me. I will find you and drag you back wherever you are." The following morning, Wendy informed Tinkerbell that Hook had assaulted her and she had been admitted to the hospital. On Tinkerbell's advice, Wendy lodged a police report against Hook. Inspector Pan interviewed Crystal, Wendy's neighbor, who gave a statement to Inspector Pan that she saw Hook forcefully holding Wendy's left hand, and in the process of trying to escape, Wendy tripped and fell down the stairs. Hook was charged with domestic violence at the magistrate's court. At the trial in the magistrate's court, Dr. John gave evidence that he was the attending medical officer on the day of the incident and examined Wendy. He found wounds and scars on Wendy's body that were associated with Wendy's version of events. Dr. John has since passed away. Hook was convicted and sentenced at the magistrate court. Hook has appealed against the magistrate decision and obtained a stay of decision pending his appeal. Wendy has since not been able to locate Crystal. Wendy has sought your legal opinion in preparation for the trial in the divorce proceeding. Okay, very important, divorce proceeding. So by reference to the Evidence Act and relevant case law, advise Wendy on the following. Okay, remember what I say? Very important. You can see there are two separate cases here. One is PP against in magistrate court, and the case Hook was found guilty and he was convicted and sentenced. Now the thing is pending appeal. Okay, there's a separate case, Wendy against Hook in matrimonial proceeding. Okay, so this is a petition for divorce. So the question A, it invites you to discuss whether Tinko Bell can be called to give evidence in the divorce proceedings. Okay, so this is an issue about what? This is basically to say whether a witness is competent witness, and whenever you see competency, it shall be followed with the issue of compatibility. Okay, take for example, normally, regardless of a civil trial or criminal trial, we need witness oral testimony. Like you have learned just now a moment ago, you have to discharge your legal burden, isn't it? I say something supported by what? By Gao coming to give oral testimony. He can testify what I said is true because he saw I was there together playing mahjong with him. Okay, something like that. Okay, so in regards to the weakness per se, you have to assess whether this is a competent weakness or not. But beforehand, I will actually advise uh, most of you lah, to start with the issue whether Tinkerbell to come to the court, would it make a difference to the case? What is his role? I mean, the Tinkerbell is supposed to be a female, isn't it? What is her role? Why you want Tinkerbell to come to the court? This is subjected to two principles: relevancy and admissibility. Don't talk too much, don't talk too much. Just a brief one. Tinkerbell, I think, is relevant because Tinkerbell can give testimony that Wendy's is having some long-standing problem with Hook, and also can corroborate the behavioral changes after losing the job. Hook start to become a changed person, every day scolding Wendy, something like that. Okay, so this is relevant. Section 5 and Section 136 can be admitted by court. Okay, and next, okay, you turn to examine the competency and compatibility of witness. Section 118, everyone should have heard about that. Unless you are those type that cannot understand when the question asks you, people ask you, what's your name? You go and answer, I live in Kulai Johor. On this type of thing, you cannot understand the question, or you cannot even give a rational answers. Okay, this is very important. These two are main categories. Cannot understand question, cannot answer rational answer, cannot give rational answers. These are those who are deemed to be uh, incompetent, cannot fit, is not fit to give a witness statement. Okay, and some of the categories are those who are tender year, young age, extreme old age, having some chronic disease of body or mind, or other cause that rendering you cannot understand the question and also answer the question correctly. So, in this particular case, I will submit that Tinkerbell is a normal person. She worked as a legal manager, so there's no indication to suggest that she cannot function. I mean, she cannot. She's distressed by mental or physical form. So she's a competent witness. Next, the issues will arise is that whether the communications between Wendy and also Tinkerbell is barred or is being privileged. We have this privileged sections is to protect, is under the public policy issues, because not everything said you can uh, you can wall it out during the court process lah. Yes, no doubt, court itself is very important to uphold justice, but it doesn't mean that you cannot share secrets with others. Take for example, we have spousal or marital communication. This is holding up the family institution as one, because as a husband and as a wife, both of you need to trust each other, isn't it? So you share secrets together. If whenever there's a case, then you can compel. Compel means force, force your wife to give something against you in the court. Then how dare you share any information with your wife? So there's no harmonization of the family as the nucleus of the society. So we back to the point. So what kind of relationship that probably Wendy and also Tinkerbell fall in? The likely one is section 126 and section 129. That is legal professional privilege. If take for example, I'm a lawyer. Whenever a client say to me, if I'm to being subpoenaed to the court to give something relating to the information that he passed over to me, I will use this privilege. I'll say, no, my lord, I cannot reveal to you. It is a privilege under section 126. I cannot reveal to you. But now the question is, Tinko Bell, who is Tinko Bell? Tinko Bell is just a legal manager. It's an in-house legal officer, isn't it? So she is not a registered advocate and solicitor. Okay. So that means to say, and furthermore, if you extend the discussion a little bit further, Tinko Bell happens to be Wendy's one of the best friend lah. Okay. So whatever they have communicated is actually not in the professional capacity, you know. So this is not something that should be privileged from revelation during the court process. And some more, very important, if Tinko Bell is to come to the court, usually Wendy will be the parties that summon, subpoena Tinko Bell to come to court, isn't it? So who does this privilege belongs to? It belongs to Wendy, isn't it? Okay, even if let's say, for example, the privilege section does exist, presumably does exist, but in this case, obviously, it is not lah. Even if it applies, Wendy can waive such privilege by consenting to the disclosure. Okay, so conclusion, since Tinko Bell was not acting as legal advisor in professional capacity, so legal profession privilege does not apply. Tinko Bell can testify in the court. So this one is fairly easy, but the difficult one I think is question B. Okay, whether Inspector Pan can be compelled to give evidence on Crystal's statement made to him in the divorce proceeding. 15 marks. Okay. They purposely give you a very high mark, I mean generous mark for the one that very difficult. Okay. So I will say that, you see, Wendy seeks advice on whether Inspector Pan can be compelled to give evidence regarding Crystal's statement made to him during his investigation. He's a police, isn't it? Into Hook's alleged domestic violence, to be appropriate. This is domestic violence on Wendy in the coming civil proceedings. So the problem now is since Crystal cannot be located, Wendy now wish to rely on her statement concerning to the incident that she saw Hook forcefully holding Wendy's left hand, and in the process of trying to escape, Wendy tripped and fell down the stairs uh, through Inspector Pan. Sorry for the grammar. That means to say he used Inspector Pan to deliver this sort of incident. So there is some component of domestic violence. So the key issues here would be competency, compatibility, and second, because 15 marks, don't be so happy. Oh, I have spotted this is a privilege issue. Then you stop that way. This will make your marks quite low. Quite low. Once you are too happy, when you just identify one issue for 15 marks, for the benefit of doubt, just think, is there any issues that has not been discovered by me? Okay, so if 5 marks, yes, you identify the competency, that will be fine. You'll be generously awarded. But if let's say this is a 15 marks, 10 marks question, think further, think critically, try to analyze the question again. Okay, I will put second thing will be general principles of hearsay, and I'll talk about section 32, subrule 1, subrule I, J or J lah, of Evidence Act, and subsequently, because Crystal has been given this sort of section 112, rakaman percakapan dalam police station, So this is also equally governed by Section 112 and Section 113 of CPC. Okay. Competency, like we have discussed, Section 118. So Inspector Pan is a competent one. Okay. Now we have to examine. Let's say Inspector Pan had been subpoenaed to this matrimonial proceeding. Can he be forced to reveal whatever Crystal told him during the course of a police investigation? Okay, so you talk about compellability. Okay, compellability is always closely related to privilege provisos. Okay, so I have identified two sections, section 124 and section 125. Okay, you can refer to the case of Reloka Peng here. This is an inquiry of death case of a very famous businessman, Bonsiu Moto. Bonsiu Moto is like a Honda Kapchai. Last time we used to have a this Honda 70 in Kampong time. We used to ride around, but obviously you're not born at that time. So you may not know who is Bun Siu also. Okay. But anyhow, section 124 state that no public officer shall be compelled to disclose communications made to him in official confidence. Okay, see, when he considered that the public interest was suffered by this disclosure, okay, and subjected to the approval of Plummer, head of department, etc. Okay, so now you have to apply already. Who is Inspector Pan? He's a public officer, isn't it? He's a police inspector. So he obtained Crystal's statement during his official investigation over the domestic violence case. So the communication, obviously, Crystal told him because he's a police. If let's say you go as a busybody, do you think Crystal will tell you? No, isn't it? So there is a component of official confidence. Okay. So um you use this section 124. Definitely, because I myself have not come across any police officer go and give testimony in a matrimonial proceeding. Okay, usually whatever statement made through the police investigation, they want the witness to talk freely with protection, so the police can collect all the information and arrest the law offenders appropriately, isn't it? So let's say this has not been done, this privilege has not been upheld by the court, it will be very harmful to the public interest. The so-called the public will lose confidence among the police officer. Okay, because the police officer can actually tell, oh, you see, Dr. Chi is the one that say he saw you hit the wife, like that. Then my relationship with the husband gets sour. How am I supposed to face him, isn't it? Cannot. So you briefly talk about the certification of head of department, but this is not so essential. As long as you highlight section 124 is enough. And section 125 Evidence Act, which I think is quite relevant also, information as to commission of crime. Here it said that no session court judge, magistrate, or you see, police officer shall be compelled to say whence he got any information. Okay, this is to protect informers. Obviously, again, you use the same argument. Crystal statement is what? Is a form of police investigation towards a commission of crime on part of Hook, isn't it? Because Hook has been charged in magistrate court for allegedly hitting the wife, take for example. And same thing, the effect of disclosure will actually harm the public. So remember what I said just now? All the privilege proviso are meant to have a social or public interest component. Okay, you get that? Then you study also you enjoy. Okay. And some more, the information is actually who is the maker of this statement? Who is the person that's supposed to have directly perceive the fact? It should be Crystal, isn't it? Correct or not? Can understand, huh? Let's say Crystal is not coming when Pan listen to the version of the story. Whatever Pan deliver to you will be so-called first-hand hearsay. Okay, so you describe as a general rule, hearsay is out because it's rumor, it's kabar angin. Kabar angin tidak boleh diterima oleh mahkamah. Okay. And Section 60 further said that whatever evidence you want to give oral, you have to come directly from those who make this statement, who see the things, who hear the voices or whatsoever. Okay. And R. Subramaniam. Okay. So this is hearsay. You must talk about that. And if the maker cannot be located, remember the section 32, general rule, section 32. When the maker cannot come, automatically you go to section 32. So section 32, sub-rule 1, it has got A to J. So which one do you use? Okay, the most probable one, I will choose I and J because it is a statement made during the course of investigation. Okay, Ah, this is our court maker not available. The precondition that apa nama you will need to use. Okay, so applying to the rules to this current case, Crystal cannot be found. Statement made during investigation, first hand. Okay, and limitation apply. Okay, you can use Michael Anayo and also Cobra Taba Sedali case. But at the end of the day, you have talked about so many things, isn't it? Okay, you only want to reach one conclusion, whether Inspector Pan can or cannot be compelled. You don't write something that juggle in between. You cannot write Section 32 1 IJ, if read disjunctively, I think can. But subsequently, you talk about hearsay, but cannot. What you want to try to say? So you formulate your answer with a firm ground. Like I said, be confident. Say no. This is no. My submission is just no. Okay? So, okay, Rick. So, I will say, no, and then will say regardless whether it is a disjunctive or conjunctive reading, Wendy cannot rely this hearsay exception in her divorce proceedings. Okay, this is not something to do with criminal proceedings. This is a civil, totally unrelated case. Okay, and in furtherance, you must also examine what is the status of Crystal statement at the end of the day. It is a section 112 rakaman bercakap. Okay, and section 112 you just briefly describe, and as you all may know, section 112 is a form of privilege um, statement, okay, by the accused or by the witness. Okay, if it is a witness type of section 112, normally the police will not give to the defense counsel. During section 51A CPC, the one that you need to pass all the documents that you want to rely during the court process to the defense counsel, for the defense counsel to prepare their case well, you cannot rely, you cannot give also this witness statement. So this is how it works. Okay. So applying, again, I use the same word, applying the law to the current case. So Crystal's statement is a section 112 statement. Okay, section 1.3 prohibit its use in evidence. Okay, so unless it could fall under section 32, subrule 1, subrule I, and subrule J. But as previously discussed, section 32, 1 and I and J applies to criminal proceeding. So therefore, Crystal's statement cannot be used as evidence under CPC in this civil proceeding. So your final conclusion, you wrap up everything. Okay? Inspector Pan competent, but he cannot be compelled to reveal whatever Crystal has said to him during police investigation due to CPC, Section 112 and Section 113 CPC, and Section 124, Section 125, privilege, and also hearsay. Can understand what I am saying or not? Okay? So what is your final advice to Wendy? Cannot call Dr. Pan to come to court. Who can understand what I'm saying? Are you all here still with me? By the way, can understand? I really hope you all can understand. I will, I will just urge you all whenever you deal with those high marks question, don't just focus, do a lengthy submission on just one issue. Sometimes it will be more. Okay, this is what I'm trying to say. So whether Dr. John's evidence at magistrate court can be admitted. Okay. So Dr. John's unfortunate passing, he died, isn't it? So render the evidence. You must assess lah. Apakah jenis keterangan ini? What is the how do you classify this evidence? Whether this is oral evidence or is a documentary evidence. And second, you need to see whether those who made the statement has come to court or not. If they are not coming to court, automatically this piece of evidence become hearsay, kabar angin, because the maker is not asked to court. Okay, and okay, so this is general starting what we call hearsay. Okay, R. Subramaniam. This one we discussed so many times. This one you must know hearsay. And remember, I have asked you to read the Evidence Act. You see, whenever who cannot come to court, you turn your attention to this. Faham tak? Okay, so my attention now turn to section 33. Okay, so what does section 33 say? Okay, section 33 say the evidence given by a witness in a judicial proceeding is relevant in a subsequent judicial proceeding to prove the truth of facts stated when the witness is unavailable. Take for example, Dr. John died. Okay, but it is subjected because hearsay itself is a common law principle that help to preserve justice. So whenever you want to go away from this hearsay rule, you want to circumvent it, you must fulfill strict criteria. Okay? So section 33, just like section 32, also has got strict criteria. What are the criteria? Number one, the evidence is given in a judicial proceeding. Yes, Dr. John is the succee, isn't it, in the magistrate court? So this one is fulfilled. So the witness is not available. Dr. John died, so fulfill. The third one is the primary contention. Okay, same parties or representative interests. Okay, in this particular case, is the PP against who? remember at the beginning of our discussion, I did mention to you there are set two cases. One is Wendy against Hook. Now it's PP against Hook. So in this particular case, the parties should be PP against Hook. Okay, because I want to push down this evidence, I don't want to say Wendy is the interest party because very hard because he's just victim, isn't it? So I will not actually rely on this. Okay, so what I'll do is I will submit as such now because this is a PP against Hook case. You get the evidence of Dr. John by this case, but now we are having Wendy against Hook. Parties not the same. So if this is not fulfilled, then generally Section 33 cannot be applied. Okay? Like that. Because if you grant this, you grant the so-called the opportunity to to admit this Dr. Jones issue, the whole characteristic of the evidence will change, Okay, this is why I submitted at the end. Like you can decide in favor Section 33 because at the end of the day, most of the criteria of Section 33 are met unless you want to submit that Wendy also becomes a witness. So these two cases are closely connected. You can submit Section 33 can apply. But my position is because one, the important point, parties are not the same. So I will advise Wendy, this evidence cannot be accepted. Okay? So this is what I'm trying to say. Okay? And my other point is that normally, again, Section 33 normally is used for criminal proceeding because they want to save time. Holding the same witness over and over again for the same matter, so no point. Sometimes one drug case, you will have different charges and Section 14, Section 6, sometimes Poison Act also got. So same group of raiding officers, same group of investigating officers. So to save the time of the court, let's say this case Jalan Dulu, the Poison Act, Senang one, Jalan Dulu, the same the photographer take, for example, he will not be asked to repeat the same story lah. This is how they apply Section 33. Okay. At the end of the day, I said it has no room for application in this matrimonial proceeding. Okay. But like I say, you can choose otherwise. You can choose otherwise because most of the criteria fulfill. Okay. I choose not. Question D, whether Wendy can refer to magistrate court conviction and sentencing in divorce proceeding. Okay, so how do you refer? First thing, it must be relevant, isn't it? Okay, so Section 43 of Evidence Act, judgment orders decrees, okay, not mentioned under Section 40, 41, 42 are irrelevant unless the word is drafted, unless they are fact in issue or is relevant, okay, under some provision of the act. Okay, so how do I go further is that I will use section 11. Section 11 is a very, very broad and interesting evidence act section. It talks about whatever that is not relevant, it can become relevant if it can prove the fact in issue or the relevant fact itself is not consistent. Like that, So it's more like a collateral issues, I would say. Okay. So applying these provisions which is generally not applicable, but then you must understand this is a divorce proceeding. So under Law Reform Marriage and Divorce Act, Section 54, Subrule 1, Subrule B, probably this is the ground of divorce because Hook had changed his behavior until boleh tahan, isn't it? So the the tingkah laku luar biasa lah, something like that. Okay, so the marriage is already cannot be salvaged under this section 54 sub-rule 1, sub-rule B. So this is the ground for their divorce. When you look at this, plus the judgment, then this sort of thing becomes closely connected. Okay, you get what I'm saying? So you use a few case law, like for example, Yi Yut Ni, Chua Chong Eng, okay, whereby generally the criminal conviction can be allowed in what we call in civil proceeding. So this has become one of the relevant fact. Okay, because Wendy premised her divorce based on the abnormal behavior of Hook. How to support this stand? A judgment in criminal court can be relevant to show, see, he got convicted for hitting me. So this is some unacceptable behavior. I cannot live with him anymore. So this is becoming a fact in issue. Okay, so this is how section 43 apply. You can use relevant judgment. Okay, and last question. Serena executed an agreement with Moon for the sale and purchase of Serena's condominium in the presence of Sun, Moon's solicitor. Sun effected the transfer and registration of property to Moon, who subsequently transferred the condominium to Saturn, Moon's wife. When Serena refused to vacate the condominium, Moon commenced legal action against Serena for vacant possession of the condominium. In her defense, Serena claimed that the agreement was a sham and an illegal money lending transaction where Moon had previously lent her 500,000 ringgit and she was compelled to repay Moon 1 million ringgit. Serena alleged that she was not able to repay the balance sum of 300,000 ringgit. Moon compelled her to sign agreement. So Serena intends to call Moon's wife, Saturn, as her witness and adduce in court a letter signed by Saturn before this agreement, reminding Serena that she owed Moon the balance sum of 300,000 ringgit. Serena also intends to adduce evidence of two similar transactions carried out by Moon with her sister, Mars, previously in which Mars has to transfer her properties to Moon when Mars could not repay her previous loans with Moon. Moon, in reply, denies Serena's allegation of illegal money lending transaction and claimed that Serena had, in the presence of Sun, voluntarily executed the agreement. The transfer forms and other relevant documents to effect the sale and purchase of the condominium to Moon. Further, Moon claimed that Serena had applied to her bank for the redemption statement to redeem the condominium from the bank, for which the redemption sum was paid by Moon that formed part of the purchase price. So advise Moon by reference to Evidence Act and relevant case law on the following. Okay, first, whether Serena can rely on Saturn's letter to override the terms of the agreement. Okay, 10 marks. Okay, if I am to say this again, it is easily spotted in this question. You have an agreement. Now the issue is that whether Serena can adduce extrinsic evidence to override the agreement that's signed by Moon and Serena. So this is parallel evidence rule. But like I say, always don't be too happy when you are catching one issue because parallel evidence is only 92 and 91. So what can you discuss further? That is the whole point. Okay. First and foremost, you give an introduction, then you say that SPA, condominium transaction, is a legally binding contract because signed by both parties. So the key issues involve whether Saturn's letter can be applied under the rules of relevancy and admissibility test and also parallel evidence rule. And on top of that, since this is a piece of letter, please also include some of the discussion for documentary evidence. Okay, you get what I'm saying? So that your answer looks so nicely draft lah, like a lawyer lah, okay? Like a senior practitioner, okay? So relevancy and admissibility. First, just briefly say section 5 relevant. So the letter is relevant and admissible because it suggests Serena O Moon 300,000. So saying that this is a debt rather than a sell. So this is a shame, like a facade to hide the illegal money lending activities. So briefly discuss. Okay. And I do agree that the main discussion for this question should be parallel evidence rule. Okay, because the question clearly asks whether the said letter can override the terms of the agreement or not. Okay, so you just discuss section 91 and 92. Generally speaking, whenever you have a contract, your obligations will be within the boundary of the four corners of the contract. Okay, so you cannot go out, cannot contract out, you cannot go in also. You understand? So that means to say, the first thing, the court look at the responsibilities of party and also what are the catch conditions towards the formation of the contract. The court will look at this contract itself, okay, before looking at the law. So what does the contract inside clause 1 say what? Clause 2 say what? Okay, clause 3 say what? Wow. Clause 4, clause 5, like for example, some collateral clauses, payment term, time is essence, force majeure clause, all this, the court will look at the contract whether it is there or not. So this is how. So section 91 said that whenever there is a contract, you reduce it, you write it, you sign it, no other oral or statement. That means whether it's some external letter, correspondence, email exchange, WhatsApp between the parties, okay, shall be admitted to add in, to change, to go out, or contradicting the form of the contract. So the contract, one side, it is four corners. Inside whatever the terms, this is the deal, final deal. Okay. And section 92 provides some flexibility because eventually contract is binding to run commercial transaction. That's why you have a contract. But somehow or other, if it is too rigid, then you cannot amend. How do you change? What if it is illegal? What is the collateral contract? What if there is some condition precedent that actually by right should be coming together? Okay, take for example, um, I buy two things and then I get one free. But the precondition to get the free things is that I have to spend money for two products. So this is amount to condition precedent, something like that. Okay, so section 91, 92, you express, but don't talk about all. Okay, because Serena, on the fact, had clearly said this could be some issues of illegality. So you zoom into which section? That is section 92A. Okay. So Serena alleged that the agreement is a sham and part of the illegal money lending transaction. You use the case of Tan Siew Hee. Okay, so oral evidence can be admitted if there is some issues in regards to illegality. But how do you justify the word illegality? Because whenever you like this, uh, you can stop like this, but at the end of the day, you have not really covered up what is illegality. In my personal opinion, if you want to get a better score, you have to combine with your contract knowledge, CPC knowledge, and land law knowledge all together lah. Okay, so I will put in just briefly lah, Section 24 Contracts Act, which forbidden it, which say that unlawful consideration in the event it is not allowed by law or it contravene the public policy or it will defeat any law, then it will render the whole thing, void ab initio. Okay, so to talk about this and what is the mode of proof briefly, because this is a letter, and then you conclude. Conclusion, because parallel evidence rule already give you the room to apply this extrinsic. Once all this you have covered, okay, then you give a nice and firm conclusion that Serena can rely on Saturn's letter. Okay, but remember you are representing moon, Okay, so whenever you represent moon, you must add on, maybe just briefly, be prepared to counter Serena's allegation, isn't it? By providing evidence to support the legitimacy of the agreement. And some more, don't just assume this is an essay question, because it is not what it is a scenario type of problem-based question. So the we call the final paragraph. What about the redemption? What about the active involvement in the transfer of property? So you are by right should protect Moon, isn't it? So you have to emphasize formal execution of agreement and actions taken by Serena consistent with a genuine self, because you want to rebut already, you want to defense. Okay, so the said conduct will actually as okay, I will put the one word here as Serena from claiming her rights over the properties. If you want some more, because there's also issue of deferred indivisibility. Okay, so you can say the house already transferred to Moon's wife, isn't it? Okay, so there's a issue of indivisibility to advise Moon. Okay, brief one. Don't go an overstatement. You have to place the concentration on 91 and 92. But to comprehensively answer this question, please include your professional advice to Moon. Okay. So second question, they ask you whether Moon can object to Serena's introduction of two previous transactions with Musk. Okay, so I will focus on the similar facts evidence. Okay, similar facts evidence. So under again, I will talk about relevancy of this. Okay, section 5. And as a general principles of law, if the laws is not concerning the current parties. Okay, namely, who is the party here? Moon versus Serena, isn't it? Now, the evidence is about Moon versus Mars, his sister, isn't it? So, if let's say these are not injuring each other, by right, this sort of evidence cannot be admitted. Okay, so this is there's a Latin maxim, what we call as res inter alios par. Okay, the remaining I don't actually know how to pronounce already. Okay, normally people stop at here. Okay, so this describe similar facts evidence cannot be admitted as a general rule. Okay, so the transaction between Moon and Mars are not directly related to the dispute between Moon and Serena. So, two different cases. So, the fact Moon had previous dealing with Mars does not directly prove to the fact that the agreement with Serena was a sham or illegal money lending transaction. Even if it's so, I mean, what you want to prove? It's a separate case one. Okay, so this is general rule. Okay. And furthermore, since this is a 10 marks question, okay, you have to identify a few cases, namely Makin and also Brockman. Okay. Actually, similar fact evidence, you have codified version. We call codified version in Malaysia, section 11B, section 14, section 15. Have you ever wondered why we need similar fact evidence? What is the rationale behind? What is the reasoning behind why we need this similar fact evidence? Okay, anyone can tell me the reason why we have similar fact evidence while I'm drinking water? Is the session taking too long, or I have not received any answer yet? Okay, similar fact evidence actually is to show some sort of modus operandi, is to show there's a repeated offense. It is done within a design, is a common practice. This is how the way you committed the crimes. Okay, for example, I want to rob a bank. I will snapshot a few pictures in front of Maybank, and then I will do the pelan lakaran. I will do a floor plan. I will also visit the bank a few times, and I'll stay to the hotel near to the bank. Every time I rob a bank, I will do like that. So this is so-called my design of crime. So similar fact evidence actually assist the court to prove the probability, the chances that you commit is you lah, never other people lah, it's you lah, because you have repeated the same in the previous case. So this time surely is you like this. So this is similar facts evidence punya purpose. Furthermore, it helps to rebut the defense of coincidence and accident. People will always say, I'm just happen to be there. It's not me. It's never me. Okay? It looks like me, sounds like me, but not me. Bukan saya. But at the end of the day, if you repeat so many times, it's the same only. The probative value is that. Okay, so the court will rely on similar fact evidence. So you use Mackin and Bodman. So Bodman actually said Mackin is more restricted to the state of mind, and Bodman had talked about strikingly similar test, which is as long as the act of the conduct is almost similar. Okay, like the example I used to rob the bank, stay in the hotel, pelan lakaran and all that is similar, then you can admit. This is a more broader one. Okay. So similar fact evidence you use again when you talk 11B, 14, 15. Okay. So this is the highline that I want you to roughly know. But section 4, 11B, if you are really smart, you can actually quote some articles saying that Section 11B, strictly speaking, may not accommodate into the similar facts one. But I don't think because this is a problem-based question, you don't need to tell so much. Okay? Section 14, keywords is to show state of mind, bodily feeling. Section 15, to tell whether an act was accidental or intentional. So as you can see here, similar facts evidence are more likely to tell you the mental element of the case. Okay? So most of the time, similar facts evidence would be used in criminal cases. Okay? And my submission is as such lah. Okay. On the fact, Serena intends to use the previous transaction to show Moon has a pattern or a tendency or propensity to force debtors in entering into a SPA, suggesting that the agreement with Serena was being caused. Okay, in this particular case, so I think there is no room for application, particularly section 14, because state of mind, body feeling to show illegality is not important at all. You get what I'm saying? Okay. Because mental element mens rea is not the fact in issue or relevant facts, unlike criminal prosecution. Okay, Section 11B also has no room for application because Serena will only need to show which law, which policies that in this country was contravened by the execution of sell and purchase agreement, or the behind the scene is the money lending activities. Which law actually bar this? Okay, and furthermore, you want to assess the court also must balance the probative value against its prejudicial effect. Because everything like this similar evidence facts evidence whenever you admit surely it's not fair to the person that you have accused, isn't it? Because the previous thing you want to bring to the current thing. So is it not fair to me? So probative value must be more than the biased cost. Okay. So in this case, I quote one case here, GCU Insurance against Asian Security Papers Mills. This is a famous case whereby the company always, the factory will burn, will get fire, and then claim insurance. They repeated the same design models operandi a few times. Then they finally got botched lah. Okay. So I will, at the end of the day, the probative value for this sort of case is very minimal because the factual circumstances involving Mars may obviously different from the one that involve Serena. Okay, so how you come is like that. You make a conclusion. Okay, uh, I think, yeah, thank God. This is the last question. So whether Serena can compel Saturn to give evidence at the trial. Okay, again, whenever there is a person, please talk about witness punya competency and compellability. Section 118 and section 120. Because Saturn is the wife of Mr. Moon, isn't it? Okay, so first submission is very simple. It is competent. The second part is a bit tricky, in which Section 122 of Evidence Act actually bar or privilege Saturn from giving the evidence that is not favoring Moon, isn't it? Okay, so the privilege actually covers the communication made between the spouse during marriage, but it does not stand to the visual observation. Whatever you see, whatever the gesture, whatever the act committed by Moon, the Saturn can tell. Okay, but not the words. Okay, so this is how does Arumugam case law. Okay, but at the end of the day, you must also realize what kind of evidence actually Saturn is going to give. Is there involved any conversation or communication between Saturn and Moon? I don't think so, I don't think so. Because when you read the whole question, when you read the whole question, where is it? Mm, you see, okay. Mm, you see, it's just reminding Serena that she owe money, isn't it? Other than that, there's no other elaboration of Saturn. Okay, so Saturn's role is very minimal, and I don't see any communications that happens between Saturn and Moon. So therefore, Section 122 actually does not apply. I will submit such lah because I don't see any communication. This is just a letter. So she's there just to testify. She signed the letter, said that Serena owe 300,000 ringgit. That's it. So since this is a communication between Saturn and Serena, the marital privilege cannot be invoked. So Saturn can actually come to court and be compelled to give information about the letter. Okay, so this is all that I want to share with you tonight. Okay, is there any question? If we do not insert, we'll get the passing. Yes, you will get a passing mark, but you try to get a little bit more lah by putting whatever that you think you can impress the examiners. Okay. Section 43, I think I already explained just now. So is there any other further question?